Your personal data's days of playing hide and seek are over. The EU's GDPR is shining a massive, unescapable spotlight on every company that touches it. First, a disclaimer. This video is for informational purposes only and does not constitute legal advice. Consult our team or another qualified professional for personalized guidance. Hi, I'm Robert, legal consultant, licensed tax advisor, and founder of Chiroptera Consulting, a legal office right here in Slovenia. We specialize in crypto law, international trade, tax, AI SaaS, and of course, data protection law. We've helped dozens of companies, from startups to global players, survive GDPR audits and build bulletproof compliance. So buckle up. Today we're demystifying the GDPR in a way that actually makes sense. Imagine this. You buy something online, hand over your email, address, maybe even your phone number, and bam, that data vanishes into the cloud. Next thing you know, you're getting spam from the other side of the planet. Not anymore. The General Data Protection Regulation, or GDPR, slammed the brakes on that chaos back in 2018. It replaced the dusty old 1995 directive and said, hey companies, personal data isn't free real estate. You've got rules now. Think of GDPR as the EU's superhero cape for your privacy. It gives you the power and forces companies worldwide to treat your data like a locked diary. Only trusted people get the key, and you decide who holds it. Why did the EU drop this bombshell? Because data exploded. Social media, big tech, hackers, massive breaches, personal information was being traded like Pokemon cards. GDPR steps in to stop money laundering through data, protect human rights abuses, and plain old creepy tracking. It builds on the European Convention on Human Rights and says privacy is a fundamental right. Deal with it. So what is the result? Trust in the digital economy goes up, bad actors get fined into oblivion. Here's the wild part. GDPR has extraterritorial superpowers. Even if your company is in the US, Asia, or anywhere else, if you target or monitor EU residents, meaning website is in English and prices are in euros, cookies, you're in. No escape. One set of rules across the entire EU and EEA. No more 27 different laws, just one big, beautiful, or terrifying regulation. So, who does this apply to? Pretty much everyone. Controllers, think of them as chefs, for example, decide why and how to use your data. Think online shops, apps, employers, etc. Processors, on the other hand, think of them as delivery guys, for example, just do what the chef says. Cloud providers, marketing agencies, payroll companies, and similar. A bit of analogy. The chef, the controller, plans the menu. The delivery guy, the processor, brings the food. But if the food's poisoned, both can get in trouble. So small startups, global giants, non-profits, even public authorities. If you touch EU personal data, GDPR wants a word. Okay, buckle up. Personal data is anything that can identify you alone or in connection with other data. Think name, email address, IP address, cookie ID, location data, and similar. Trickier to spot are the indirect data, like the guy who bought red shoes size 45 in Ljubljana last Tuesday. But if that is enough to identify him, that's personal data. Up next, all data is not equal. Under GDPR, there are special categories of personal data which receive extra protection. They are called sensitive data. Think health, religion, biometrics, politics, ethnicity data, and similar. For processing sensitive personal data, you need explicit consent or another strong reason, a legal basis to process it. What about anonymized data? When we talk about anonymized data, we mean it is censored or changed in such a way that it is impossible to re-identify the person with that data or a collection of data put together. Under those circumstances, anonymized data gets a free pass, since it does not fit the definition of personal data, aka identification of a person. And what about pseudonymized data? Like data that has names replaced with codes or nicknames. It is still personal data if the pseudonymization process is reversible. Now the fun part. GDPR flips the script. You, as a subject whose data is being processed, have the following 8 super rights. Firstly, the right to be informed about your personal data a third party is processing. Secondly, the right to access your personal data. Thirdly, the right to rectify mistakes in the personal data a third party is processing about you. Next up, we have the right to seek erasure of personal data, also known as the right to be forgotten. You also get the right to seek a restriction on processing of your personal data, right to portability of your personal data, right to an objection to processing of your personal data, right to not be subject to automated decision-making, and there is an extra bonus right, the right to lodge a complaint with your local supervisory authority in cases of infringement. Now for the controller duties. The GDPR lays down strict obligations for the controllers of personal data, such as that the controller may only process personal data if it has lawful basis for such processing. We will talk about this topic in more detail in another video. Next up, the controller also must follow one of the main principles of GDPR, which is data minimization, meaning that the controller must limit the data processing, this also includes data collection, to a minimum. So no data collection for just-in-case purposes. The data controller must also offer an adequate standard of accuracy, security, and prompt breach notification. In some cases, where the controller is doing big-scale or high-risk data processing, it must appoint a DPO, Data Protection Officer, to ensure compliance. When big-scale and high-risk data processing is involved, controllers are also required to conduct a DPIA, Data Protection Impact Assessment, to address the risks involved with such data processing and to try and mitigate them. Controllers must also sign adequate contracts with any and all processors, ensuring adequate protection for your personal data, even when the processing is outsourced. Last but not least, prompt records, traceability, and transparency in processing is key to establish a safer place for personal data in the AI rising digital world. What happens if you do not play by the rules? Fines up to 20 million euros or 4% of global annual turnover, whichever hurts more. And yes, regulators are collecting millions and millions in fines already. So there you have it. GDPR turned personal data from a free-for-all buffet into a fortress with you holding the keys. It protects privacy, forces accountability, and yes, sometimes adds a lot of paperwork, but the result is a safer, more trustworthy digital world where innovation and rights actually coexist. Stay compliant, document everything, train your team, and keep an eye on EDPB guidelines. Because the spotlight is on, and it's not going anywhere. If this video helped, smash that like button, share it with your network, and subscribe for more no-nonsense legal breakdowns. Need GDPR help for your business? Check our Knowledge Center for more free content, or contact us, link is in the description below. Thank you for watching, and remember, compliance with the law prevents the flaw. Till next time.